I now invite Chief Justice Dame Sian Elias to speak. The guiding hand on the New Zealand High Court for the past 11 years, there's no one more qualified to be our final speaker on a night devoted to the theme Magna Carta and the Kiwi Constitution. Chief Justice, the podium is yours.
Ena mana ena reo rangatira, tēnā koutou katoa. Why should it matter to us what happened in a meadow between Staines and Windsor 800 years ago? Now, the short answer I would give is that the Magna Carta, first adopted at Runnymede in 1215, is an important part of our constitution. I agree that a constitution, I agree with Judith Collins that a constitution is not the preserve of courts, it's not the preserve of lawyers. It needs to be talked about. It needs to be a living force in the life of a country, otherwise we lose it. So the great thing about the 800th anniversary of Magna Carta is that it provides a welcome opportunity to do just that, to talk about our constitution and how it was formed. Now, I have to acknowledge that my perspective, you might not think this is surprising, is what some commentators have dubbed the lawyer's view of Magna Carta. And oddly enough, you might think, lawyers are said to be romantic about Magna Carta. They're not normally thought of as romantic people, but less oddly, they're also said to be bad historians. Now, it's not necessary to go quite as far as Lord Bingham, probably in my time the preeminent judge of the common law world. He described the Charter as the most influential secular document in the history of the world. Now, that sort of makes you boggle a little bit. I'm sure that a very convincing argument could be made for it, but I'm not going to make it here. But the lawyer's view of the Charter is that it stands up for the ideal of the rule of law and sets it up in our constitutional arrangements. Now, the lawyer's view is often contrasted with what is said to be the historian's view, which is sceptical of the Charter's constitutional significance and its resonance today. Now, I'm not sure to what extent Dr. Diggleman takes that view, but that view emphasises that the Charter was extracted for reasons of self-interest by a gang of disaffected barons, largely, it's said, from the north of England, although recent scholarship suggests that it was much more widespread than that. And those who subscribe to that point of view point out quite rightly that the ideas we see in Magna Carta in the context of the 21st century would have mystified those who had a hand in its creation. Those who take this view of Magna Carta say that it dropped from view until revived by Lord Coke in the 17th century in the clashes between the King and Parliament, and that Coke himself invented the lawyer's romantic notion of the Charter. Now, there is much that is valid in the view that the Charter must be seen in its own light and that it can't carry too much baggage. And the history of the Charter in all its versions, and Maitland always said when you're referring to Magna Carta, you have to say what version you're referring to. The history of the Charter is exciting enough to repay study in its own terms and in its own times. But it is interesting that modern historical scholarship, aided by modern methods of research, has turned up much more information about the circumstances of the obtaining of the Charter and its then contemporary effect. I think there's probably a third view of the Charter which grows out of the influence of the Charter on the great constitutional battles of the 17th century, and it might be called the political scientist's view of the Charter. That is, that it is a critical step in the shift of power from the King to the King in Parliament. This, it has to be said, is slightly romantic thinking too, which is not surprising since the parliamentary party of the 17th century included notable lawyers. So it's just as well we've had on this panel the Honourable Judith Collins to speak to the influence of Magna Carta on our parliamentary traditions. Through the Treaty of Waitangi, so coming to New Zealand, through the Treaty of Waitangi and the system of government it enabled, we imported into New Zealand the statutes and common law of England in effect in 1840, including the provisions of Magna Carta still in effect. And there were more at that stage than there are now in New Zealand. So in law in New Zealand, we are as old as the inherited common law and its rich history, and the early charters, first of which in time is Magna Carta, which drew on the older common law and which galvanised the common law in its turn. Now, I must admit that as a young lawyer, I was never very sure of what parts of Magna Carta or what parts of English law at 1840 remained in effect. And I once had the very unnerving experience in the 1970s, or maybe in 1980 or 1981, of being left as junior to make a reply in a case where senior counsel had had to leave before the reply. Senior counsel was the very learned David Barron QC, and he had raised Magna Carta in his argument. The judge had sat there like a lamb when he was speaking, but had got a bit suspicious overnight and certainly was a little bit terse with me. Now, on comparing notes with another junior barrister in our rooms, Robert Chambers, I found out he'd had exactly the same experience when acting as junior to David, and neither of us had a clue whether Magna Carta was an artefact of any relevance or force at all. My recollection is that the judge was similarly mystified. Certainly there was no mention of Magna Carta in the judgment. I think Magna Carta was thought of in those days as the sort of fighting talk which you avoided in polite submissions. But of course, David Barron was quite correct to treat Articles 39 and 40 of the 1215 version of Magna Carta as part of the law of England. He was a man of much higher scholarship than Robert and me. And in 1988, as Dr. Diggleman has said, that was made perfectly clear by the New Zealand Parliament, by the Imperial Laws Application Act, which lists the legislation of England still in force in New Zealand. Although they are listed in order of seniority, Magna Carta appears second. It comes after the Statute of Westminster I of Edward I, but that's only because the version of Magna Carta which is enacted for New Zealand is that which was entered on the parliamentary roll in its reissue by Edward I in 1297. So the only clause in New Zealand under the Imperial Laws Application Act which is preserved is the celebrated provision prohibiting imprisonment, disseizing people of their properties and so on, without lawful judgment of his peers or by the law of the land, and providing the pledge for the administration of justice: we will sell to no man, we will not deny or defer to any man either justice or right. This is Clause 29 as entered on the Edward I version, but originally it was Articles 39 and 40 in the original version, although they weren't numbered, so it really doesn't make much difference. The Edward I version is almost identical to the subsequent reissue by Henry III when he gained his majority. And as I said, it remains law in New Zealand. So Magna Carta came to New Zealand and remains a provision recognised by our legislation as constitutional because in the Imperial Laws Application Act it is contained in the part of the schedule which is headed constitutional provisions. So the significance of the Charter. It has, of course, had its detractors. Cromwell jeered coarsely at it, but then he was levying taxes without parliamentary authority. Legal philosophers in the 19th century thought that its exaltation by people like Lord Coke was romantic antiquarianism or special pleading, which ignored the special interest at work in its creation, and it's said to have been misunderstood in its own terms. And it's true that the terms of Magna Carta are often misunderstood, and inevitably myths have grown up around it. It's true that there's nothing in Magna Carta that was truly new, except for some of the specific provisions addressing grievances. Similar promises for good government had long been made by Anglo-Saxon and Norman kings. Contrary to folklore, Magna Carta did not establish habeas corpus or trial by jury, nor did it establish parliamentary control of taxation. Although it treats taxation by the king without the council of the land as contrary to law and custom, the council had not yet developed into anything like even the rudimentary parliament of the time of Edward I. But in Article 14, which provides for the summoning of the barons and the bishops to advise the king, there are indications of a felt need for wider and more systematic representation in the council advising the king. Magna Carta does not point to the repositioning of the sovereign power to make law, as in the king and parliament. Still less does it say anything about democratic government, nor does it protect the independence of the judges, which wasn't secured until the Act of Settlement in 1701. All these things lay in the future, and their achievement was by no means made inevitable by the Charter. But none of this diminishes Magna Carta. More importantly, the folk memories of the importance of the Great Charter of the Liberties of England, as it was called in the Petition of Right of 1628, and their persistence in popular estimation tap into enduring values despite the politics and self-interest of the moment in 1215. The clauses of the Charter repay reading, especially in the more accessible translations which have been produced for this anniversary. They indicate a seedbed for the development of law and protection of liberty realised in succeeding centuries. The clauses of the Charter protest against arbitrary deprivation of liberty and property and look to proper legal process. If the term due process of law is not used in Magna Carta, due process of law is the effect of the promises. The provisions of Magna Carta are concerned that justice is not corrupt and not delayed. It is to be provided by royal justices who know the law and are committed to fulfilling it. The Charter also looks to common laws and common measures and weights. It's concerned to protect trade and free movement of merchants, and this it indicates a society in great change. The magnates cannot do without the towns and the merchants, both of which are specifically mentioned. The quarrel which gave rise to the events of Runnymede is based in the abuse of feudal privileges, and there's much in the Charter which, as Dr. Diggleman says, looks back. But it's clear from the text of the Charter that, as Ferdinand Mount puts it, the middle classes are on their way, and 50 years later, knights and burgesses, as well as barons, were summoned to the Parliament of Simon de Montfort. So the effect of the Charter. If the Charter represented in its day in part claims for restitution of freedoms and liberties long known, what is interesting is that it was also a departure. Demands for the good old days were not made after Magna Carta. Instead, the focus changed to confirmation of the Charter and the better securing of its promises. Subsequent reforms invoked the Charter. The Charter was widely known and widely distributed. Encroachments on freedom were resisted in its name, both in the remainder of the 13th century and later in the times of growing absolutism under the Tudors and Stuarts and the dictatorship of Cromwell. It was cited in opposition to arbitrary power to imprison or take property, taxation without parliamentary consent, and development of Crown prerogative powers. The Charter was critical in the battle of ideas which eventually led to parliamentary government. It's not fanciful to see in the terms of the Charters ideas central to the rule of law and which have influenced modern statements of rights. It has been cited in the courts from the 13th century down and in all jurisdictions which have inherited it. It continues to be cited and was, for example, an important plank in the reasoning of the US Supreme Court in Rasool and Bush in 2004, which held against executive imprisonment in Guantanamo Bay. While some of the claims made for the Charter were not wholly correct as a matter of history, one legal historian, Sir John Baker, says that makes no difference. Magna Carta, he says, though not in any sense a written constitution, was morally entrenched. And Chapter 29 in particular was the chief legal weapon deployed against growing absolutism. So I want to conclude by saying something briefly about future directions. Moral claims, or claims as the Honourable Judith Collins said, claims on the conscience of lawmakers, are not the same as legal right. In our legal system, moral or political claims are a twilight world. Magna Carta and legislation and the law which it has given rise to, is at least acknowledged to support claims of right recognisable as law in the courts. But entrenched rights they cannot be in a system of parliamentary supremacy, as Judith Collins says, which is why Baker accurately identifies them as morally entrenched only. How secure is moral entrenchment? It would be nice to think it is as secure as formal entrenchment, but that can only be if there is widespread understanding and willingness to work harder at maintaining what is essential in our mostly unwritten constitution, in which the rule of law shadows but is unequally matched to the legislative supremacy of Parliament. Magna Carta lays the foundations for the rule of law and parliamentary sovereignty, the twin elements of the New Zealand Constitution today, as the Supreme Court Act so far says, although I'm afraid that's about to go in the new Judicature Modernisation Bill. But the 800th anniversary of Magna Carta may be a good time to take stock of how well they are serving our society. It is puzzling, I think, that the constitutional conversation we have had to date seems largely hung up on the identity of the head of state, an element of the Constitution that actually seems to work quite well. It seems reluctant to engage with bigger ideas, such as the fulfilment of the ideas set loose at Runnymede in the circumstances of today. Magna Carta confronted the arbitrary power of the Crown. Over the following centuries, the ideas it launched brought the Crown under the law, as Bracton and Cook insisted it was. The King, they said, was made by the law. Is Parliament itself made by the law? Sir Owen Dixon of the High Court of Australia thought it was. If so, is it subject to law, as James I had the wit to see was the implication of his being made subject to law? Is arbitrary power acceptable today if exercised by a parliament which is democratically elected? Now, these are very big questions. Lord Hailsham, then the once and future Lord Chancellor of England, was raising questions such as these in connection with the Constitution of the United Kingdom in his Dimbleby lecture, provocatively entitled Elective Dictatorship, 40 years ago, and his paper is worth revisiting. It accurately identifies some of the strains now evident in the Constitution of the United Kingdom today. In recent years, there has been much change in New Zealand that is properly characterised as constitutional. The New Zealand Bill of Rights Act, the change to the system of electoral representation, and the Official Information Act in particular, they've been transformative. They may be sufficient change for now. Our pragmatic and adaptable constitution may suit New Zealand society and indeed has considerable virtues. It would be foolish, however, to think that constitutional evolution is at an end in New Zealand. And even if change in our institutional arrangements is not in prospect, a largely unwritten constitution needs to work, and constitutional values may provide political limits, at least if they are talked about and understood. One thing we can be sure of is that in the necessary discussions we will continue to have on constitutional directions, the ideas of Magna Carta will continue to be drawn on, as they have been for the past 800 years. Nō reira, tēnā koutou, kia ora tātou katoa.